share.
Terrific. Thank you.
You got it. Okay.
Hey Dan, how you doing? This is Mitch.
Hi, Mitch. How are you? Good afternoon, everyone. Let's get started. It's 2 p.m.
How do I
Welcome
get the volume on
to.
here?
Okay, I'd appreciate everybody mutes.
Oh, there we go. I got you.
So good afternoon, and welcome to Professional Bank's web conference titled "Navigating Unprecedented Times." I'm Dan Sheehan, Chairman and CEO of Professional Bank, and today I'm joined by Stephen Schwartzberg of Schwartzberg and Associates, who's been focused in the area of employment law for close to 40 years, and Romeo Chico, the founder of PayMaster, a payroll service provider that currently serves a wide range of clients in a variety of industries located in all 50 states, Puerto Rico, and the U.S. Virgin Islands. For those of you who are new, Professional Bank is one of the most active banks throughout South Florida, supporting small business and their financial needs, which puts us in a unique position to help many of those businesses get through this disruptive episode due to the COVID-19 virus that we're all dealing with right now. While we're eager to help those affected, some of the details still remain on the SBA PPP program under the CARES Act. I'm told as recently just an hour ago that we may have details later today, and the first loans might start flowing on Friday. Nonetheless, Professional Bank is a preferred SBA lender, is currently preparing to open up the program as soon as we can. And we're again hopeful it's this week. So, but aside from the financial lifeline that the SBA intends to provide, and we plan to serve as the conduit and bridge for our many clients, many businesses are still facing a lot of tough decisions regarding their employees, payroll taxes, severance, and other layoffs. And that's why we have our two guests and experts that come in to talk to us. Both Steve and Romeo plan to do a presentation each, and then we'll have time for Q&A. So let's get started. Romeo, I'll hand it off to you.
All right, thank you. Thank you, Dan. Steve, I think you're gonna allow me to share?
Yes. There you go.
Thank you. All right, so here we go. So I'm going to, as Dan mentioned, I'm going to jump in and cover the acts and how they apply to businesses. Of course, some of these acts expand out beyond that, but again, my focus today is how this applies to your business in regards to payroll and employees. The first act is the Family's First Act. This was signed back on March 18th. It's set to take effect April 1st. So that means things that may have happened up to today, they don't count. It starts tomorrow. There is a non-enforcement period that allows you to implement this up until April 17th. And after that, you really need to comply with this. What I'm reading in the act is violations will trigger a Fair Labor Standards Act minimum wage, and we don't want any of that. And that's what Steve will cover. So my disclaimer is that these acts are passed in Washington. After they're passed, it takes a little time for the agencies to then come up with the regulations behind it. And where this presentation is right in the middle. So as I give you the presentation, some of the information is at this time solidified by the respective agencies, and some we are still waiting on further guidance and definitions. And I'll try to point that out as I go along. So the Families First, it applies to employers with less than 500 employees. That count is at the time somebody wants to take leave under this act. So at a client I spoke to the other day, they had close to 2,000 employees, and that was 3 weeks ago. Now they have under 500, so this act would apply to them. This act provides employees with two types of leave: a sick leave and an expansion on the Family Medical Leave Act. And it is for employees who are out of work due to a reason, which I'll cover on the next slide. So they must be unable to work or telework. These two leaves will go away on December 31st at the end of the year. Hopefully the virus is long gone by that point, but that's when these sunset. The reasons an employee can be out on leave are one of these 6 reasons. They are numbered, and there's a very specific guideline behind each of these numberings. So the first 3 are the employee is out for their own well-being. So the employee is subject to an isolation or quarantine. They've been advised by a healthcare worker. I've seen some employees come in with notes to their employer or email them in saying that they've been advised to quarantine for 14 days. Or certainly the third option is the employee directly has symptoms and is seeking medical diagnosis.
Yeah, I turned
A question I am asked is in regards to number 1. We have this stay-at-home order. From what I read in the definitions, that does not qualify as a quarantine or isolation. The Department of Health and Human Services come up with those 2 definitions as very specific, and it is not a stay-at-home order, unfortunately. Now, reasons 4, 5, and 6 are the employees out for the benefit of someone else. So the employee is the caretaker for someone who's been diagnosed or subject to quarantine. Or the employee child under the age of 18 is out of school and they are having to stay at home to care for the child. Number 6 is a provision that we believe is there for them to throw in some future reasons. So it's kind of just 1 through 5 at the moment. Now, if an employee is out for one of those 6 reasons, reasons 1 through 4 and 6, the employee is eligible for 80 hours of paid time off. If they are part-time, this applies to all of your employees. So if you have someone who only works 10 hours a week, they are also eligible for this. The amount of time someone can take off is the average over the past 6 months. So again, you could have 1 or 2 employees in your company and you're required to provide this paid time off. Reasons 5 allows the employee up to 480 hours. That is 12 weeks. It is a long time. And if we just go back to the reasons, number 5 is the employee is out caring for a child who's out of school that's been closed as a result of this, or a caretaker. So that is a lot of time that you now have to pay your employees. There is a limit on the amount of wages you can pay. I think it is a very generous limit. And again, it depends on the reason. 1 through 3 is $511 per day, $5,110 over that 2-week period or for the year. And the reasons 1 through 3 are the employees out for their own well-being. 4 through 6, the employee is limited to 2/3 of their pay. So if an employee gets $30 an hour, they're limited to $20 an hour. And it is up to $200 per day. Now, reason 5, we saw on the prior slide that they can take up to 12 weeks off. It is also at 2/3 of their pay, and they can take still $200 a day, $12,000 max. 1 through 3 and 4 and 6, the employee could have just been hired. Reason 5, they want the employee to have been hired within the past 30 days. So and again, regardless of their full-time or part-time, it's if they were hired 31 days ago at the time they want to take this leave, they're eligible. Now, since the government is forcing you to pay these benefits out, all this paid time, they are really giving it back to you in the form of a payroll tax credit. So the amount that you pay, that amount is 100% eligible for the credit. The IRS is trying to make you as whole as possible, so they're saying the employment taxes that are related to those wages are also eligible for credit, and your share of health insurance. So all that is eligible, bundled up into that credit. You can take that credit against your next payroll tax deposit. So if your normal tax deposit is $10,000 and you have $2,000 in this credit, you just deposit $8,000 and you've got the immediate benefit. The IRS realizes that there are cases where the credit can far exceed the amount of your deposit. They just released last night. It is IRS Form 7200. It is just a draft, so you can't file it yet. They're kind of just hanging it out there, so we know how to program for it and account for it. It's Form 7200. I have seen documentation where the IRS says they are looking to process this form within 2 weeks. So again, given time for mailing and mailing a check, it does appear to be a fairly quick turnaround on any credit or over credit. Now, one of the leaves it is reason number 5. If an employee is out for these 12 weeks, it is job protected leave. That means after 12 weeks, the employee can come back to you and say, I am here and ready for my job back. And you need to provide that job back for them. There is an exception out there that if you have less than 25 employees, you can claim an exemption from this. And I list the points there. So this may be in play for a small employer who doesn't have the resources. Also, if you want to exempt yourself from this paid leave, you can. The form is not yet available. That's going to come from the Department of Labor, and I just checked 10 minutes before jumping on this. Still not available yet. But if you have less than 50 employees, you can opt out of this. So I spoke to a business the other day. She said that basically all of her employees are parents that have a child out of school, and she would have to close her business if everyone elected to take this 12 weeks of leave. She can't afford that. So she's looking to possibly claim an exemption from this. Right. So that takes care of the Families First Act. The second act, which was just passed on Friday, so there's still a lot that's yet to be defined by the respective agencies on this. It's a 900-page act. I have read it a couple of times now as to what it applies to employers, and I'm still reading it to try to get a grasp on the totality of it. There are 3 sections that I believe apply to businesses with employees. The first, Section 2302 in this act, is you can defer your payroll tax deposit. It is only your share of Social Security tax, so it is not the taxes you withheld from your employees. It's not Medicare. It's not any unemployment tax. It's Social Security only. You can choose not to deposit that tax for the rest of this year. And then you can make 2 equal payments, one December 31st, 2021, and the other half December 31st, 2022. So it's significant amount of time that you can hold on to the IRS money without having to deposit it. Second piece is there is an employee retention credit. They're making this retroactive, and there are two conditions to qualify for this. And if you qualify, which is your business is fully or partially suspended due to an order. So if the easiest case is if you're a restaurant, you were ordered to close down your in-house dining, perfect example. Or the second option is you've had a significant decline in revenue. And they have defined this, which I didn't go into the details because it's a little lengthy, but in short, you had a 50% decline in revenue this quarter as you did in the same quarter last year. If you qualify, then half of your wages up to $10,000 per quarter. And I've seen some discrepancies on this. And, you know, again, I've read this part 4, 5, 6 times. It appears to be per quarter per employee. So you can take a significant amount of the wages you're paying your employees and keep them on the payroll. And what they're trying to do is saying, well, if you were to terminate them, they're going to get that $600 extra per week from unemployment. May as well try to keep them on the payroll and off of that unemployment. Again, you can increase the amount of your credit by the share of your health insurance. And you can't count towards this 50% of wages anything you paid under that family sick leave because they're giving you that money anyways, so you can't double dip. The third part that has to do with payroll and employees is this Paycheck Protection Program combined with loan forgiveness. We have businesses with less than 500 employees, loans up to $10 million. The basis of the loan is 2.5 times your average monthly payroll over the last 12 months. So it's a pretty big amount. If you have anyone over 100,000 on payroll, you have to reduce your 2 times amount by anything that's over that. So limit for any highly compensated employees. And the deal with this is you get the loan, and in summary, if you keep the same amount of employees coming out of this at the end of June as you do going in, you can request a forgiveness of the loan up to 100%. It is prorated, so if you had to decline some employees, it's prorated. Any amount that is not forgiven is prorated, is payable over 10 years, no greater than 4% interest. If you are an employer and you've terminated employees as of last week before this came about, you're being encouraged to hire them and possibly pay them under this. From what I understand in the Act and what I read, it appears that you can only take one of these 3 options. So if you take this payroll tax deposit and you say, okay, I'm not going to make my deposits for the next 6 months, that would stop you from getting a loan forgiven. And I think this is the better deal for businesses. So kind of free money is better than delaying payment of the money. And I think that covers the CARES Act. The last piece that I want to throw in here is something that I found in the Florida statutes a few weeks ago. And that has to do with unemployment. And if for businesses that have been around for many years, back after the housing crash and 9/11 and all the disasters we've had in the past, as you lay off employees, they collect unemployment. The claims that are paid by the state go against your record, and your unemployment rate will go up. It was not uncommon back in 2010 for us to find employers with the 5.4% unemployment tax rate, highest rate there is in Florida. As a result of the current layoffs, because the president, I believe on March 13th, declared the Robert T. Stafford Disaster Act, it has triggered this in the Florida statutes that says any benefits the state pays will not be charged against the employer. I am not certain, and I am thinking it's not going to be an automatic reason that the state is just going to go, oh, you terminated someone this week, it must be because of COVID. I do believe you're going to have to respond to that unemployment notice and identify that this was the reason. So, be adamant about this. Make sure you respond to that notice that the layoff was directly related, and make sure you keep an eye on your benefit statement that comes out towards the end of the year. Usually it's sometime in December that identifies what benefits have been paid, and make sure these are not against your record, because you don't want that rate sitting with you for the next 3 years. So the last point is is our website. I put this web page together a couple of weeks ago because information is coming out on a daily basis, new forms, new definitions. We are updating this web page daily. So it's paymaster.com/COVID-19, or just paymaster.com. And have lots of links out there to the full acts, resources, and a lot of information to help employers. I don't have things on there like wash your hands. You can go to CDC for that. This is just business related for employers. So with that,
yeah, thank you, Romeo. I really appreciate that. I'm sure there'll be some questions to follow up on your presentation. Steve, are you ready?
I am ready.
Okay.
I am here. Romeo, thank you very much for that very informative presentation.
you're welcome, Steve.
Steve Schwartzberg here, and I'm very pleased that Dan Sheehan and Professional Bank allowed us to put this together for you. And I appreciate all of you attending, especially under very difficult circumstances. We'll do our best to provide you some relevant and important information. So let me start with my presentation here. Okay, can everyone see my presentation starting? Yeah, Romeo? Okay. So there are a lot of considerations that come into play now that the pandemic is upon us and new laws and statutes are being passed. And a customized approach is necessary for any given business. One size doesn't fit all. If your business may be opened or closed in whole or in part, maybe yours is an essential business or industry allowed to remain open. Maybe you've furloughed employees or laid them off temporarily, which is really the same thing. Or maybe you've terminated or permanently laid off employees. Can your employees work or telework from home? Is it the kind of business that allows that to happen? Are the employees afflicted themselves? Are they caring for a family member who's afflicted? Or are they caring for a child not in school? There's some initial pragmatic items to consider. Maybe one of the more important items, and I come from a litigation point of view and dealing with conflicts and counseling clients, how to deal with problems that come up, is to obtain employment practices liability insurance, EPLI, if you don't already have it, in anticipation of what I think is going to be a frenzy of employment litigation, in part claims unleashed by the workplace disruption. People filing claims who in the past would not have filed had everything stayed status quo. And then there's going to be, with the avalanche of new laws, rules, and regulations, which are difficult enough to follow and implement and abide by, there's going to be an onslaught, no question about it. There are already plaintiffs' lawyers advertising for clients with claims they may have. I suggest that it's important to be wary of potential whistleblower claims. As you know, the role of the whistleblower has assumed great importance in our society now, and a lot of employees are going to be talking about whether they can file whistleblower claims, where they object to the company violating a law, rule, or regulation. Can any of you imagine a company violating a law, rule, or regulation in today's environment? Sure. And as a result, if that employee has some adverse employment action taken against him or her, that employee may go to a lawyer and claim that they're a victim of retaliation and that they're actually a whistleblower. In fact, there are provisions in the Families First Act itself which expressly forbids retaliation if an employee attempts to take advantage of legal rights. Likewise, be wary of exposing the company to a claim made by an employee or anyone else under the Federal False Claims Act, also known as KETAM lawsuits, a suit brought by a private citizen, a whistleblower, against a person or company who's believed to have violated the law in the performance of a contract with the government or in violation of government regulation, when there's a statute that provides for a penalty for such violations. So there's going to be, I think, an avalanche of KETAM False Claims Act claims where employees and others are going to that's a misstatement. They're going to report and file lawsuits against companies who are believed to have taken advantage of the situation, et cetera. If you're a company which has furloughed employees and they remain on your roster, another tip is to be, and one of the reasons you did so is to make sure the employees could retain their health insurance. You have to remember to make sure you continue to make the premium payments. And if the employees were paying a part of it and they're not able to right now in this limbo period, you may want to make sure that you're making the full payment for those employees. So one of the first questions to start with, believe it or not, is who are your employees? Because as you know, the Department of Labor and the EEOC have had certain programs in place the last number of years to go against employers who have misclassified their workers as independent contractors when in fact they really qualified as being employees. So if you've got statutes that relate to employees in particular, you want to make sure that you haven't misclassified them. Note that in the acts which have just recently been passed, there's coverage not only for employees but also for sole proprietors and independent contractors. So you just want to be sure that you've classified your employees correctly, and if you gave them a 1099 and included them as independent contractors when they weren't, but they really are in fact employees, you may want to make sure you abide by all of your obligations, not just under the two acts, but in general as to those persons. So maybe, even though it's a difficult time, it may be a good time to do an audit to make sure that you've classified everyone correctly. There's 6 factors that the 11th Circuit Court of Appeals follows that governs us. And it has to do basically with, number one, is the work that person doing an integral part of the employer's business? If yes, then the worker is likely an employee. If that person is doing something different that has nothing to do with that business, they might be more likely an independent contractor. Does the worker's managerial skill affect the worker's opportunity for profit or loss? Do they just get a flat rate for hours put in and they really can't do something to manage the work where they would make more profit, make more money? Third, how does the worker's relative investment compare to the employer's investment? Whose equipment, whose machinery, whose resources are being used will affect the answer. Does the work performed require special skill? If you're professionally oriented and you're doing professional level kind of work or specialized work, then it's more likely you're an independent contractor. Is the relationship between the worker and the employer permanent or indefinite? Lastly, what is the nature and degree of the employer's control over what the person does? Does the employer tell that worker exactly what to do and how to do it, or is it left to the worker to make those decisions? The courts weigh these factors. How many factors are on one side or the other, and how important are they in a particular case? One of the main areas that we're going to have to pay attention to is under the FLSA, Fair Labor Standards Act, involving overtime and minimum wage claims. And as Romeo pointed out, violations of the Families First Act may result in claims being made under the minimum wage provisions of the FLSA. Florida has a higher minimum wage than the national figure, and each state may have their own provision. So Florida is currently $8.56 per hour. If someone works overtime, the minimum wage is time and a half, 1.5 times that amount. So you want to make sure you're paying at least minimum wage, and if you are, don't make deductions from minimum wage. There's some businesses that will charge their employees certain costs, and once you do that, you can be opening yourself up to a claim for a large number of employees. You want to look at who's exempt and who's non-exempt. I've represented clients in the past when hurricanes take place and natural disasters. They have a certain number of exempt employees, but because of the emergency, the duties of those employees shift a little bit, and now those employees are doing a lot of non-exempt duties, but still being paid a salary, but they're working much more than 40 hours. Some of those employees have filed claims against my clients for overtime and actually been in a position to recover. So if the duties of exempt salaried employees change and they're no longer exempt because their duties change, then make sure they're keeping track of their time and you're paying them overtime. If someone was exempt before the pandemic, and if their duties changed, then are they still exempt? Same point. Now, if you have exempt employees, you want to be careful not to improperly dock the employees. If everyone could mute their speaker, I would appreciate it. You don't want to improperly dock the employees for partial days, hours off here, or part days off. If someone works for part of a week who's exempt, then they're entitled to get paid for the whole week. Because remember, if they're exempt, it doesn't matter how many hours they put in, they just have to get the job done. But if you have a particular day involved, you can't dock someone, you could blow the exemption. You want to make sure you're keeping track of hours for everyone. That's the employer's responsibility. It can never be put on the employee to keep track of hours, etc. So you have to, and you want to be careful because you may get sued later on a claim, and you want to be sure that even persons who you're treating as exempt keep track, because later they'll claim they weren't exempt, and they'll claim they worked 100 hours a week. So you even want to have them keep track of their time. Someone has not muted their mic, and we can hear your voice. If you could mute it, I'd appreciate it. I don't want to mute everybody, but maybe I should during this period. Let me try to avoid that. Try to avoid retaliation claims. Under the FLSA, if someone makes a claim for overtime, even if it's oral, even if they don't use the magic words, they may have a claim for retaliation if adverse action is taken against them. So if an employee says, boss, you didn't pay me for all the hours I put in a lot of hours this week, 50 hours, and then the next morning you fire them for that reason or some other reason, you'll get sued for retaliation. And the damage can be much worse than overtime you might owe, because now someone's out of work for a year before they get another job. Remember, when life returns back to normal and employees regain their exempt status, try to document how their duties have now changed and gone back to exempt duties. Avoid discrimination claims. You know what the protected classes are: race, religion, national origin, disability, gender, etc. You want to be sure that if you're making certain decisions, don't open yourself up to a discrimination claim where you're treating all women one way and the men a different way, etc., etc. Believe it or not, there can be harassment and hostile working environment, even if we're teleworking. So you got to be very careful not to disparage certain workers or say certain things or open yourself up to that kind of exposure. And of course, you have to avoid retaliation if somebody engages in protected activity and makes a complaint or participates. Under the FMLA, there's a general obligation on part of the employer as an affirmative duty to provide FMLA paperwork if you know or have reason to know that an employee has a serious health condition or otherwise qualifies for FMLA. So once you learn that someone may qualify, you can't just sit back and wait for the employee to come to you. You have to send the packet or have your HR department send the packet out. Similarly, under the ADA, if the employer knows or has reason to know an employee has a disability or is perceived as having one, even if the employee doesn't, the employer must engage in what's called the interactive process to see if a reasonable accommodation is requested, needed, and should be provided. They should be provided unless it works a hardship on the business. So there is an exception to that. Under the NLRA, National Labor Relations Act, which most people think governs only organized union environments, it also applies to non-union. An employer has to be careful not to interfere with employees participating in any concerted protected activity. For example, they might be complaining about work conditions or the employer or complaining about the employer. And if you retaliate against that employee, you may be violating the NLRA. And just today, it turns out that Amazon fired an employee who was protesting against the company. He was holding up a sign, "Treat your workers like your customers, stop the spread, stay home," etc. And I don't know if this is the person who was fired, but they actually got a pretty big wallop by being exposed, say, for having fired somebody who was organizing other workers. You want to avoid individual liability as a principal of the business or a manager. First of all, you want to consider who's the company. I mean, before we asked who's the employee, who's the company, there is such a thing as joint employment liability. So you may think that if you're involved with 2, 3, or 4 companies and you've got distinct entities and you think you're handling everything perfectly for 3 of them and the 4th one maybe you're not paying correct attention to, you may get sued later. Not only the company that you think is directly involved may get sued, but you may find that 1, 2, or 3 of the other companies may get sued as joint employers if those certain conditions are met. So keep that in mind. There's also such a thing as joint enterprise liability for minimum wage and overtime claims. If 2 disparate companies are both involved in a joint enterprise, there could be liability on both. So you want to be careful about who you may be engaged in joint ventures with. And of course, there are common law theories for alter ego liability and mere instrumentality. You want to make sure you maintain your separate corporate existence and don't merge and meld personal funds with corporate funds and treat the company like a piggy bank, because you may find out that you're exposing yourself individually unwittingly. On payroll taxes, Romeo spoke about a lot of relief and credits and delays and extensions on the payroll taxes, but be careful where if funds are running short and the business is cash poor, when you're taking when you have obligation on payroll taxes or you're deducting, make sure that you're not helping yourself to funds that you should otherwise be paying into the IRS timely. Otherwise, you'll have personal liability. On Fair Labor Standards Act minimum wage overtime claims, there is personal liability for someone who's a principal or a manager. So be careful on that in that area in particular. And under the FMLA, sometimes the individual decision maker can have individual liability as well. So you want to be careful there. Plus, in torts, these are very trying times. So a lot of employers are making a lot of promises and representations to their employees and others. So be careful about getting sued later for fraud and misrepresentation. Maybe there's invasion of privacy. You're disclosing some information about somebody that you shouldn't be because we're teleworking. We're not in our normal environment. You have to be careful about the intentional torts. There's potential punitive damage liability, which would not be covered by liability insurance, and it would not be something that would be dischargeable in bankruptcy. So you want to be very careful about that. OSHA has a general duty clause, and it has to do with the obligation of an employer to have a safe working environment. At the beginning of the pandemic, it seemed to be more applicable, where if somebody traveled to China and was coming back, or someone was sick, you had a duty to make sure that that person didn't expose others in the workplace, to the virus, et cetera. an employer still is going to have to be careful during this pandemic to still comply with this general duty clause. And even in the back end of it, when we start coming back to work, you want to be careful that you do what you need to do. There are certain good practices to follow. Here's a little list that I've made. Malcolm Gladwell wrote the book Blink, and in the book he talked about the part of our brain that's working behind the scenes. It's well known that doctors with good bedside manner don't get sued for malpractice, as a generalization. The brilliant doctors who gave perfect medical care but have horrible bedside manner get sued much more often. So basically, be an employer, be a manager who communicates with employees, stays in touch, be human, respect, protect their privacy, don't do invasion of privacy, comply with HIPAA obligations. You want to review your company leave policies and other policies, revise your handbook as necessary, create and implement new policies as necessary. You want to make sure you document everything you're doing. We're all displaced. It's hard to document, but you're going to need it later for a lot of reasons that I've referred to. Retain documentation. Stop automatic document deletion programs. Make sure you have everything backed up, especially the way we're working right now. You want to be sure that whatever is important is backed up. And you want to be able to explain your rationale for decisions you're making to staff so they understand. If you're going to give a severance, at least get a separation agreement signed by the employee, get a general release for any claim the employee may have. They may be happy with the severance now, but when it runs out, they'll be mad and they'll see a lawyer and maybe make claims. You want to protect yourselves. And you have to be careful about group insurance, because if there's some employers who will furlough employees, they're not doing any work, but they'll keep them on the policy, the group policy, but the policy itself may provide that they're really not actively working for that reason. And there may be a policy problem. So contact your benefits coordinator, broker, and ensure that the policies allow inclusion of those kinds of furloughed employees. If necessary, amend the plans. Make sure COBRA is administered timely as well. You don't want to have any of that kind of liability. If you have business interruption insurance and you think a basis exists, talk to your broker. If you have contracts in place of a general nature, there may be provisions in the contracts or common law provisions that would apply. Everyone's talking about force majeure. Unless there's a earthquake, a volcano, a hurricane, or pandemic, everyone sort of skips over the force majeure paragraph of these contracts because it just seems unimaginable that something would happen where people would be in the condition we're in right now. Well, it just happened. So see if your contracts have those provisions. And if they don't, there are other common law defenses you could have, or people you're contracting with might have, based on impossibility of performance or prevention, et cetera. Even though we're still working, teleworking and being disrupted, you still have to protect your trade secrets and confidential proprietary information, sometimes the most important, valuable asset of your business. And the most important thing I could tell you is stay in touch with a professional bank. That is, I was not told to say that, but you want to, it's good to be the king, Mel Brooks said. It's good to have a good relationship with your banker, and you have a great bank here. So I would encourage you to do that. As you can tell, Romeo and I are very involved in our niche and our industry, respective industries. So anytime anyone has any questions or comments, I'm happy to hear from anybody. I thank you for listening. I'm sorry if I blurted out too much too fast. And I just want to thank you for participating. And I wish you all good luck. I know it's a hard time for everybody. We're all in this together, and we're all going to do the best we can together. So let's help each other.
Thank you very much, Steve. So everyone will notice there's a chat feature in Zoom. If you want to submit a few questions, we've got roughly 16 minutes left in the hour. If you'd like to submit some questions, start typing them in and we'll start answering them. While folks are given some time to do that, I'd like to pose a few questions. Perhaps this would be best suited for you, Steve. But I know that a lot of our clients recently or over the last couple of weeks has been forced to make the tough decision about letting folks go. Since hiring folks back is a big component of the Triple P program under the CARES Act, what is the best method for hiring those folks back, especially if some of those relationships might have soured, or if in some cases you might have been planning on letting some employees go anyways? Where do you draw the line? What's the best outreach program to get folks back on the payroll, et cetera, understanding the risks and sensitivities that you just shared?
I think it's a great question. I'm going to exercise discretion and punt to Romeo because he's smiling. I recognize that smile where some people would call it a churlish grin, where he has something to say, and then I'll follow with a comment.
Yeah. So, yeah, there are two aspects to this. There's the aspect as far as the act itself. And what that says is, all right, you may have terminated someone weeks ago, and now there's credits out there. Now there's money available for you if you had employees. If you hire that person back, the acts say it's as if that person never left. So, for example, on the expanded family medical leave, it says they have to have been employed 30 days. Well, the 30 days is from when they were terminated the first time. So if they were terminated and they'd been there for a year or 31 days, and you just hire them back today, they are now eligible. So from that aspect, hire them back. As Dan mentioned, if there's a bad relationship or maybe you didn't want them to begin with, well, then don't hire them. I don't know how, if Steve wants to say how it acts when, you had a separation agreement and now you're saying, all right, come back. I guess you have a separation agreement now to deal with.
And are you responsible or at risk, Romeo, for that back pay? Let's assume in an example, someone has not been paid for the last 2 to 3 weeks. How is that addressed?
Yeah, I haven't seen anything that says you have to pay them. If they were terminated, didn't perform work for 2 weeks, they could have filed for unemployment. They could have gotten unemployment benefits, during that time. So there's no pay involved.
And what about adjusting the terms of the previous pay? So you're bringing folks back, they were getting paid X, you're hiring them back today. Under the new business model assumptions, the store hours have changed. You're going to be utilizing less man hours. Are you able to adjust the pay today going forward without corrupting some of the qualifications and standards you need to meet under the Triple P program?
Yeah, so that program, it has some specifics in it that you have to, when you come out of this, they need to have roughly the same number of employees, the same amount of wages. So if you do decrease wages, hourly rates, or decrease salaries, that could affect that loan being forgiven in the full amount. So you do have to be careful if you are bringing people back in order to qualify for that. You may not want to cut their hours. I mean, the whole purpose of that is they're giving you 2.5 months of payroll to pay your employees as if they were employees over the past year. So if you start cutting their wages, then you're not using that money to pay your employees.
Okay, understood.
Just a comment or two. I think that the statutory scheme has been developed as an incentive to hire back employees who have been let go. And I think that employers are encouraged to do that, and they're given financial incentives to do it. I have ambivalent feelings about the psychology of it. On one hand, if you furloughed half your employees and you fired the other half, when you get around to hiring back the half you fired, you may find out that they don't like you. They don't love you the way they loved you before. So that's a factor. On the other hand, if they're upset, they got fired, they may start liking you again if you hire them back. So it's hard to tell. But you're gonna have to, you're in this gap. I don't see any reason why an employer wouldn't want to try to get, as a condition of hiring the employee back, execution of a new release for the gap, whether you got one before or not. If the employee, what'll hurt more than anything is to go through the process of hiring the employee back and finding out a month later or 6 months later that you got sued for something the employee claims you failed to do during that period. On the one other issue while I have the floor, there's some incentive for employees being able to file unemployment if they're let go because of the pandemic, and the employer could get some benefits with the rate not going up, et cetera. You want to be a little wary of exactly how you articulate that, because you want to be sure that you're not creating an admission where an employee claims later that they actually qualified for paid leave, they wanted it, and they were fired because of the virus, because they were ill or diagnosed, they were seeing a doctor because they were ill, et cetera. They may have a retaliation claim. So be careful when you respond back to unemployment, be careful not to do it in a way that might unwittingly expose you to a retaliation claim.
That's a great point. I'm going to go to the message board here and ask a few questions. The first one's for Romeo. The question is, can you clarify how the employer would get the tax credit for the 12 weeks provided of paid leave due to reason number 5?
Yes. So any of those FFCRA credits, so the expanded family medical leave for the 12 weeks or the standard 2 weeks of the sick leave, the amount of wages you pay out, plus the tax, plus the employer health insurance cost, that amount you can subtract from your next payroll tax deposit. And for most businesses, that tax deposit is due 3 days after check date. So you are getting that money right back by withholding taxes. And if the amount you pay out is in excess of your tax deposit, then there is that new tax form that's coming soon, tax form IRS 7200, which will let you apply for an advance of the refund.
Got it. So next question, this is an interesting one, and it makes a lot of sense, but you go back to an employee, you hire them back, and let's say they refuse to work. The question is, can that employer force them to use PTO? Or maybe they haven't technically been fired, but until the program's released and money starts flowing from the SBA, which could be another week or two, can an employer force the employee to use PTO in the interim period?
So the sick leave under the FFCRA, the employee's decision whether they want to use that or not. So if your company has PTO and they have some hours there and they also have this family sick leave, they can choose which one they want to take. An employer can't say, oh, you have to use the federal government's first. So it is up to the employee. There's a labor poster that was just released late last week that you're supposed to put up, I believe by April 17th, that advises the employees of their rights. You can find it on the Department of Labor Wage and Hour Division, or again on our website, I have a link over to that poster, which will advise the employees of that benefit.
Got it. Great, thanks.
Danny?
Yeah.
Generally, I recall that the employer cannot force the employee to use PTO first before the employer meets their obligations under the Act. So I agree with what Romeo said with regard to it's up to the employee as to how he or she wants to handle it. But it sounds like the employer is not going to get off the hook on the PTO obligations because of the enactment of the statute. So, and the employee is going to make that decision.
Got it. So another question is related to the credit elsewhere test. I was on a call earlier today where one of the attestations that borrowers will need to attest to is that they haven't applied for other programs and or the same program with other institutions. They don't want folks double or triple dipping. So one question is, Kate came in, I have already applied for the bridge gap, but I'd prefer to do the paycheck protection program. Can I deny the former to stop it in its tracks once the application's been put in?
And the bridge, is that the Florida Disaster Loan.org? If it is, that is a $50,000 loan at 0 interest for 1 year. That has no bearance on these federal. So that loan you can take out, and you can take out this this new paycheck protection loan. So you can't have both of those. You can't have the paycheck protection loan and delay your federal tax deposits. You can't have those things combined.
Got it. Another question is a certain employer has had his employees furloughed for now, has every intention of bringing them back. But, you know, as we all know, one of the anticipated requirements, given the name and all of the feedback we've been getting, is to in fact bring employees back. What date should they bring them back? You know, you want to bring them back when you have the money, but can you get the money before you bring them back? And so does anybody have a sense of sequencing and what the anticipated timeframes would be to bring folks back, anticipating this money being available?
My first initial comment is it sounds like a cash flow kind of answer. If you've got the funds and you know what's down the pike soon, and you have a higher comfort level, maybe you'll hire them back on your own nickel until the money becomes available. But that's just one reaction. I don't know if there's a magic answer to that question.
Okay. Next one is I have 2 employees that can use the Family First. Can they utilize the paycheck protection, or does that disqualify the whole program? So if I understand that correctly, 2 employees, do the 2 employees being on that program perhaps DQ the program for the overall organization?
Yeah. So the credits for the sick leave and emergency family medical leave, that FFRCA credits do not interfere with anything under the CARES Act. So you can pay your employees that are out on that Family First leave. You're taking those tax credits for the wages you pay, and you are quite fine to defer your tax payments or take out the paycheck protection. That does not interfere.
Got it. Another question, I guess it has to do with sequencing. We have not laid anyone off now, but given the time, I imagine the unknown time for funding the PPP, should I lay off people now and rehire them at the time once I know the clarity on when the loan's going to be funded? But in the meantime, just use whatever funds available to just pay interest, rent, et cetera, normal operating expenses, X employees.
So I think Steve mentioned this, is that a cash flow issue? So if you don't have the money to advance to pay to your employees, I mean, that you shouldn't keep them on the books. If they're on as active employees, you need to pay them. Otherwise, you're going to have minimum wage violations and other problems. So I would think it would be understanding of an employee to say, hey, look, there's no business. I have no money. I can't pay you. Your best option is to file for unemployment. They'll get paid there, and possibly very well with the federal now kicking in an additional $600. That could give someone $870 of unemployment. And then when you have the business, actually I spoke to someone last week who was saying they feel that their competitor is going to be unemployment, because now you have someone who's getting $870 to do nothing, collect unemployment, and you want to hire them back at $12 an hour. They're making more than $15 an hour doing nothing. So they feel that they would have a hard time getting their employees back off of unemployment. But I would say if you don't have the money, you have no other option other than letting them go until you can get some of this paycheck protection loan or some of these others.
I agree.
And you can correct me if I'm wrong, Dan, but from what I've read, that once you are able to do a loan under this program, it's a same-day decision and the same-day funding. So it doesn't appear like they would have to wait a week or 2 weeks. It's again, the language I'm seeing is like same day, which is amazing that it could happen.
Yeah, that's what we've heard. So the rumors are that they're going to try to limit the application to one page. I'll believe it when I see it. And they're setting up a digital portal for all of the banks directly to the SBA to input and register all the required information and make the funds available. That is our understanding as well, Romeo, that these funds will be provided right away. They will be non-recourse. They will be forgivable, meeting certain criteria. They will not require collateral. And fundamentally, this is more of a grant. It's being presented as a loan because they want its constituents to understand that there are certain requirements to meet, and you need to track the intention of the loans. But for all intents and purposes, this is a grant. It's our intention at Professional Bank to get this into the hands of our clients as quickly as possible. But we can only, unfortunately, move as quickly as the government does. And again, I mentioned that earlier on, we do expect more detail out tonight. Rumors are that we might be able to, or the banking industry in general, might be ready for Friday for taking on our first applications. That would be great. Another question, we've all heard about the 2.5 times months payroll. You want to talk about just the math on sizing the loan? It's 2.5 times monthly payroll, but it's also certain qualified expenses.
The 2.5 months appears to be designed to, based against the average, appears to be designed to get us out to 2.5 months into the future, April, May, half of June, which must be based on projections of health concerns. But tell us again, your question was what specifically? I forgot already.
Well, it's just the math and sizing the loan. It's not just 2.5 times your payroll expense or monthly payroll expense. There's other certain qualifying expenses that could fit into that. For instance, interest on debt, rent payments, etc.
I'm not sure, Romeo, you may know, I'm not sure if the number is based on those factors or the money can be used for those purposes. I know the money can be used for those purposes. I don't know if those costs come into play in the amount.
Yeah, I mean, the major piece of it, from what I see, is 2.5 times salary, wages, commissions, vacation, not including any of this federal sick leave. You subtract that out. It also includes group health insurance, your cost, retirement benefit costs. So if your employer contributions to 401k plans, unemployment taxes, and looking down my list, I think that may be it. But the biggest piece of that is, well, your 2.5 times salary, wages, and it's the lesser of that or $10 million.
And what are the implications? Do either one of you know how this might affect the H-21B visas for international employees? Any clarity on that?
Yeah, that I have not seen anything regarding that.
I see another question regarding, retroactive uses. Tomorrow's the first of the month. Many folks, rent is due. It's my understanding that qualified expenses extend back to February 15th. Is that your understanding as well?
I do know it's retroactive. I think I have seen the date February 15th. I
believe
don't have it handy.
Period is between February 15th and June 30th.
Yes, that date does sound very familiar, but I don't have it handy in my notes.
Another question, I'll answer. The question is, will Professional Bank be providing these forms? When will the forms be available? And when will the exact disclosures of the criteria to be applied in order to be able to get these loans? This is a very fluid situation. Again, our SBA team, as well as the executives at Professional Bank, are all on a series of calls with lawyers, politicians, and the SBA in some respects, talking about these programs. We're still waiting on Treasury to provide all the details. Again, just to reiterate, we expect more detail and more guidance by tonight, with the hope, I think it's Treasury Secretary Steve Mnuchin has gone on the record now a couple times this week already, indicating their goal is to start accepting applications this Friday. You can be assured that our team is focused on this matter. We've been repurposing some of our bankers and some of our staff to ramp up and scale our SBA platform. What's great, we've got a really talented banker, Omar Ojeda, who's been running our SBA lending platform and desk for the last several years. He's very involved, and we are going to be swift and responsive in meeting all of your requests. As soon as we get a copy of the application, we're going to make sure it's easy to get to on our website, and all of our bankers will be educated in helping and assisting folks fill these things out and get it submitted.
Great.
So, there's still a handful of questions coming in, and we could probably spend another hour or so doing this. Steve or Romeo, are there any last minute, comments or statements you'd like to make before we wrap up? I think that what we could do is provide a follow-up email with a link to this recording, and we will include the contact information for both Romeo and Steve, so you can reach out to them, and if you have any specific questions where their professional expertise could help you, we'll plan to do that. So, Steve, Romeo, is there anything in closing you'd like to share?
Romeo.
No, there's just a lot of information coming out, and in my doing my own research, I have read the acts, and there are some things that are not clear when you read it, and I have seen conflicting information on different websites. So just be careful of what you read out there. Don't take anything for granted if you see it just once. And make sure you do your homework, do your research.
I want to say in conclusion, I can make an assumption that most of us are analytical drivers in what we do. We've done well because of our intelligence, IQ and EQ. With having discussed all of this specific technical information, I think the one takeaway is to stay human in everything we do. It's going to be hard to know the exact answer, but I think if you err on the side of the human approach, I think that everyone will benefit more than not. The procedures and policies and resources are in play. It's a timing issue, and we just have to get to the point where everyone can take advantage of it and get us through this tough time. We haven't hit we're not close to the peak yet, certainly not in Florida, but we have a big tragedy awaiting all of us around the country. If the projections of numbers dead apply, we're going to be dealing with things a lot more difficult than what we've been discussing today. So I wish all of you to stay safe and flatten the curve, and continue to do the best we're all doing to try to take care of our respective families and work families. So Dan, thanks for making this available to everyone and making it possible for us to try to share the little bit of insight we can provide here today.
You got it. And there's one last
thank you.
point. And there's one last point I'd like to make too, just so everybody gets a sense of the scale and magnitude of this program. So the 7A program last year, there was $20 billion of origination and placement in the calendar year 2019. We're talking about deploying $350 billion just in a 3-month period. Every bank, big and small, is focused on this initiative. It's the right thing to do. We want to get the money in the folks' hands, in our clients' hands. We want business to succeed. And I would just caution you, like everything, there will be, I would bet, folks out there that aren't lenders or aren't preferred lenders with the SBA, aren't banks. And so just watch yourself for folks presenting themselves as lenders and so forth on the internet. Make sure, come to Professional Bank. If you talk to others that are banked with somebody else, make sure you go to an FDIC insured finance institution. That way you will ensure that everything you're doing is proper and appropriate. There might be scammers out there just looking to get information from you. And you want to be careful. So please deal directly with a bank, and Professional Bank is going to be ready. But thank you for everyone today. We'll follow up with an email, the recording. Stay safe, stay healthy, and we will get through this. Thank you, Steve.
All right.
Thanks, Dan. Thanks, everybody.
All right.
So long.
Thank you.
Thanks, Romeo.
All right. Bye-bye.